Tennessee Court Talk is a podcast presented by the Tennessee Supreme Court, Administrative Office of the Courts. The aim of the podcast is to improve the administration of justice in state courts through education and understanding. The target audience varies and is announced in the beginning of each episode. Welcome to Tennessee Court Talk.
I'm your host, Barbara Peck, and today we are discussing criminal pattern jury instructions. This podcast is intended for legal audiences, including judges, lawyers, and law students. Our first guest is Judge Chris Kraft. He is the chair of the Tennessee Judicial Conference Pattern Jury Instructions Criminal Committee. Judge Kraft is a criminal court judge in the 30th Judicial District, which encompasses Shelby County. He was appointed to the bench in 1994 and has been reelected 3 times. Our second guest is Judge Mark Ward. He is the co-chair of the Tennessee Judicial Conference Pattern Jury Instructions Criminal Committee. Judge Ward is also a criminal court jury in the 30th Judicial District. He was appointed to the bench in 2004 and was subsequently reelected. Our third guest is Judge D. David Gay, who serves on the Tennessee Judicial Conference Pattern Jury Instructions Criminal Committee. Judge Gay is a criminal court judge in the 18th Judicial District, which encompasses Sumner County. He first took the bench in 2006. Welcome to you all.
Thank you.
So last year, there were over 5,700 criminal jury trials in Tennessee, ranging from assaults to capital murder cases. Have you, as a judge, ever felt like the outcome of a case was affected by the jury instructions?
Well, of course, the jury doesn't know what the law is, and that's what we do. We take the law the legislature gives us, and we tell the jury what it is. And so every case is affected by the jury instructions because the jury has to understand the law, and then they come up with the facts, and they have to put those two together to give us a verdict.
Judge Ward, you ever felt like the outcome was affected by the instruction you gave?
I'm not sure the outcome was affected by the instruction as much as the case that may have not gone to trial because of the anticipated jury instructions. I've had cases before that once the attorneys realize the exact nature of the instructions, what I'm going to tell that jury, all of a sudden they decide to settle the case. So I think it affects the dispositions without a jury trial as much as it does the actual trials.
And that was one of my questions as well. So there was about 157,000 dispositions last year. So only, if you look at it that way, only 5,700 went to trial. The other 150,000 were disposed of without trial. So obviously you feel like the jury instructions really affect those cases that are settled beforehand as well.
Well, I think if the attorneys prepare for the case, and preparing also includes realizing what the instructions are going to be. And once they realize that, sometimes it eliminates potential defenses, for instance, or a potential claim that the defendant wasn't aware of what they're doing at the time of the crime. When they read the instruction and find out it doesn't require intent, things of that nature often result in the case actually settling.
So when do you think an attorney should first look at the jury instructions in a case?
When they're first retained by the defendant or appointed by the court. I think the attorney who's preparing the case for trial, number one, should have in his trial notebook exactly what they expect the jury instructions to be, exactly what their proposed special request should be, but not just at the time of trial, but all the way back to when they first get on the case. First thing they should do is anticipate what the jury instructions are going to be from the trial judge, so that when they interview their clients, when they interview their witnesses, when they're preparing their arguments, their voir dire questions, their opening statements, they're gearing those things to what they anticipate the jury is going to be told the law is. So I think from the moment they're hired on the case, they should start thinking about what is that judge going to tell the jury the law is. Because the truth is, it really doesn't matter what the law is. What matters is what the jury is told the law is by the jury instructions.
Particularly like murder cases, when the defendant decides right after the state's proof, I'm not going to testify, which is his right, and I tell the lawyers, I'm not charging self-defense because there's been no proof of self-defense. And a lot of times they decide they'll go ahead and settle the case.
Judge Gabe, what do you think about the timing of when a lawyer should first look at the jury instructions?
Well, I think that a lawyer first needs to look at the jury instructions somewhere in the discovery process, and I think it's very important that that is communicated to the defendant, so that the defendant can gauge the evidence that's going to be introduced against him, compare it with the jury instructions, and make a decision about whether or not he wants to proceed to trial or whether or not he wants to settle the case. A lot of times defendants are influenced when they know that the judge is going to charge a certain element, and he's going to say, wow, or she, I'm in trouble. I also agree with Judge Kraft. I think every case that's tried by a jury is affected by the instructions. We're dealing with people here that know nothing about the law. So you start with beyond a reasonable doubt. Nobody has any idea what that means. And by the time I have a case that goes to deliberation, the jury's going to hear that definition at least 3 times. But take a DUI. Most people think that you need to be publicly drunk. But if you look at the instruction under the influence, they'll see that it doesn't require that level of intoxication. So a lot of things that people might think about the law is different, and it's borne out, I think, in every case.
So let's talk a little bit about how the committee that you all serve on develops these instructions. So tell me a little about the history, Judge Kraft. We're on the 22nd edition of the pattern jury instructions in Tennessee. And tell me a little bit about the history of them.
Well, since I'm the oldest, I'm probably the one that remembers. Back in the 70s, I tried my first jury trial as a lawyer in 1977. The judges, a lot of times, just talked to the jury. They weren't in writing, and they just told the jury instructions. We didn't really know what was going on. Then, when the rules were changed in the 80s, that you had to give written instructions in felonies. Still in misdemeanors to this day, you don't have to give written instructions. But they had to be written down. And so we had to give the trial judges some patterns. And they were slowly developed in loose leaf notebooks. And every time the law changed or there was a new case, they would give judges new pages to put in their book. And a lot of times the judges would not get them in the mail, or they would put them in and still use the old ones and not throw them away. So in 1996, we started the publishment of a paperback book, and we change it every year that Thomson Reuters puts out. And we do all the work and give it to them, and they do the book, and then they give us free books for our work. But all the judges have that book and a CD that they can use for the charges. And the legislature keeps changing the laws every year. And also the judges keep having different requirements as far as the Supreme Court and the Court of Criminal Appeals. And so we have to keep abreast of those charges. So we put them on the website, and then every October our new book is published so that the judges have it.
So tell me about the process a little bit, about how the committee changes the instructions and the comments and the footnotes.
Well, we meet every year, and for instance, we just an hour ago, we had a new a new elder abuse law that's taken place January the 1st of 2020 in a couple of months. And so we had to go through the new jury instructions to put in that book, which has already been published this year. And so the committee had to go through, we discussed them, we made some tweaks, and we agreed on how to take what the legislature said, some of which is a little complicated because it's made for laws and not jurors. For instance, there'll be a phrase that you need certain things on a crime that the law says requisite to constitute the offense. Well, a juror won't know what the word requisite means, so we'll change that to say needed to constitute the offense. And so we try to put the legal language into language that ordinary people can understand. Usually the ordinary average juror in Tennessee doesn't even have, a lot of times, a high school education. And so we have to make sure that we take complicated legal terms and make them to where normal people who aren't lawyers can understand.
So there is a lot of studies out there that says that jurors rarely understand jury instructions. Hopefully that is not the case in Tennessee. But
Absolutely.
How does the committee balance the quest for plain language that you were just talking about with the need for legal precision?
Well, that's the tough part, is to make sure, and we also come from different jurisdictions. I'm in a metropolitan jurisdiction, and there are a lot of people who are in rural jurisdictions where the average juror may have not an 8th or 9th grade education. And so we have to make sure that we put it, in fact, the Administrative Office of the Court sent me to Philadelphia one year to take a course on how to take legal concepts and put them in ordinary language. And we'll have jurors that'll ask questions, what does a certain word mean? And we'll have to put it in ordinary language so that they can understand it. And if it's too vague, the appellate courts will let us know, and we'll have a case, and then we'll follow that case. But we try to get it right the first time.
And how does the committee use the comments and footnotes to update the jury instructions if you're not updating the instruction actually itself?
Well, we don't. The comments are for the judges. We will have the pattern instructions, but sometimes they shouldn't be used in certain types of cases or if you have certain types of fact situations. And so we footnote our instructions so that the judges and the lawyers, who hopefully have looked at the instructions ahead of time, they will know what the cases are. A lot of times lawyers say, well, I don't think you should charge this, or I think you should charge or instruct the jury this. We call them jury charges. And then we'll have that case to show them that, because we have to follow our appellate courts. And then we have comments, because sometimes judges get in trouble and they tend to charge the wrong thing. And so we'll refer them to that comment to explain that to them, because a lot of judges in Tennessee, there are only 33 criminal court judges. The other judges try everything, and they'll try 2 or 3 criminal cases a year, if that. And so we need to make that instruction book to where all the judges can understand it, even if they're not really familiar with criminal law.
And Judge Ward, what about the timing of jury instructions? I think there's some different philosophies out there about when jury instructions should be given to the jury. Do you have a philosophy it should be before, so when they're listening to the evidence, they sort of know what the instruction is going to be, not until they get the case, both? So what is your approach?
My approach has the jury instructions given at multiple times during the trial. I give some instructions before we pick the jury. Once we get a jury, I give some additional instructions, preliminary instructions, and then at the close of the trial, I'll give additional instructions. Now, I say at the close of the trial, I give my instructions before the closing arguments so that the attorneys, during their closing arguments, can refer to the instructions. Right now, our current rules of criminal procedure give trial judges the option of charging the jury before closing arguments or charging the jury after closing arguments. The last time I checked, I think the predominant practice here in Tennessee by most of us is to charge the jury before the closing arguments. But I start with the instructions before we ever pick the jury, and then give additional instructions after we get the jury, and then finally instructions right before closing arguments.
And Judge Gay, how do you approach it?
I approach it the exact same way that Judge Ward does. Prior to voir dire, then right before we start the case, and then before closing arguments. I think it's very helpful that you cover the elements at that time for the jury so that the attorneys can plug that in and the jury is familiar with those elements of the crime.
I think it's very important when you have jurors that first come in and they've never been in court before. Usually a juror's experience as a juror is the first time they've ever had it in court, maybe except for a divorce. And they'll see someone sitting there charged with a crime. They may be prejudiced against them because they're just charged. They may be of a different race or a different gender. And so right on from the start, we need to talk to the jury about presumption of innocence. There's not going to be any bias or prejudice. Prejudice means to prejudge. We have to deprogram them from all these criminal law shows that they see on TV where people make speeches in the middle of trial. So it's important that we take charge right from the beginning so the jurors know that they have probably the most serious obligation that a citizen of the United States has as a juror.
One thing I try to do, Barbara, is ensure that they can be fair and impartial before they hear any evidence, and that takes care of sympathies, bias, prejudice, and set them up to where they lay all that aside and they can rely on the evidence that comes in and apply that to the law. That's essential. That's what we do when we pick juries. So we must get them in that frame of mind. And as Judge Kraft said, we've got to deal with the presumption of innocence and beyond a reasonable doubt, and the fact that the defendant doesn't have to do anything.
Yeah, as soon as they see the defendant, the first thing in a juror's mind is, I wonder what he did. And they start that way wrong to start with. So we have to let them know there's a presumption that he's innocent. And so good judges are proactive to start with and keep that during the entire trial.
And what about how you communicate your jury instructions? Do you do it in writing? Do you do it orally? Do you do it as a mix, multimedia presentations going on in your courtrooms? How do you handle that?
As I said already, I give an instruction at the beginning before we pick the jury. I give that orally. And then after we pick the jury, I give some preliminary jury instructions. I give that orally. But my final jury instructions that I give right before the closing arguments, I do that in writing. And one practice that I have always adopted is I provide each individual juror with their own copy of those jury instructions. That's not required by law, and some judges still, although they give the instructions in writing, they sit there in court and read those instructions to the jury, which we are required to read them to the jury, but I think it's important to provide them with their own individual copy to read from, because it makes more sense to them if they're reading along with the judge as the judge is reading it. And I tell the jury, that's your copy of the jury instructions. You can circle things, highlight things, take notes, do whatever you want to on your copy of the jury instructions. And I think that's an important practice. And I think almost everyone in Shelby County now provides a written copy of the jury instructions, the closing instructions. I don't know what the others do.
Barbara, what I do up in Sumner County, I follow the exact same procedure for the first two different instructions, and then when we do the closing instructions, I have the instructions on the screens in the courtroom, and we have two screens there, and as I read the instructions, they follow along, and that seems to work well up in Sumner County.
And so these are obviously pattern jury instructions, but sometimes they're changed before in a specific trial. So which sections, in your opinion, are most negotiated or most changed before they get to the jury?
You mean argued by the lawyers?
Yes.
They just argue.
They just argued by the lawyers, yes.
Yeah.
Which sections?
In my mind, it's usually lesser included offenses. We'll have someone who's charged with committing a murder, and the defense attorney will want them charged with simple assault, for instance, even though someone died. Or you'll have someone charged with a sexual crime, and they will want an attempt to commit that crime, even though the crime was either committed all the way or it was not. And then you'll have the prosecutors who want all these inferences drawn, like to tell the jury that he fled, and they can use that to show that he was guilty when there's really not much proof that he fled. And so both sides come at you with that, and you have to, instead of, they don't negotiate it, you just have to do what you think is right. What does the proof show? You have to look at the proof and see what you think it shows in order to give that instruction.
Other than lesser included offenses, I occasionally have an attorney submit a special request for a defense that they're raising in the case. And they submit a special request because they don't like the defense that's in the pattern jury instruction. There's something about that that's not beneficial to their client, so they come up with a new instruction and request that it be charged. And occasionally I have done that, but most of the time I stick with the pattern jury instruction because it's the safest bet. The other thing that happens occasionally, we have some of our instructions that have alternatives, not more than one way to charge the jury. And in some cases, some of the alternatives are attempts to modernize the language to make it simpler to understand. And sometimes when I prepare my jury instructions, I will have one alternative and they might request a different one. But quite frankly, I don't get very many special requests almost everyone that tries a case anticipates that it will be tried with the pattern jury instruction, and most of the attorneys are happy with the pattern jury instructions.
Barbara, there's no doubt that the instructions that are most negotiated are lesser included offenses. We all struggle with those issues. I also, like Judge Ward, ask for special instructions from both sides so that we go into that having everything discussed and everybody knows going in what's going to be instructed.
The hardest one is in death penalty cases, when the defendant's been convicted of murder in the first degree and the jury has to decide whether or not there's death. And the defense lawyer suggests mitigating circumstances that you charge to the jury. I had a defense lawyer ask me one time to charge as a mitigating circumstance to the jury that this young man's family went to Disney World and he was not allowed to go, as a mitigating circumstance in the death penalty. And then I have to decide whether or not I think that is mitigating as far as a death sentence, and I ended up charging it. But the more serious the crime, the more important it is when there. And a lot of times, the defense particularly is trying to get the judge to make a mistake, because in case he's convicted, then they can appeal it. The prosecutor is not trying to get us to make a mistake, but the prosecutor's not too worried. They just want to get a conviction. And so what we have to do is we have to do what we think is fair and just and what the law is, when all the other lawyers in the courtroom, that's not what they want. They want convictions or acquittals.
So from an advice standpoint, what advice would you give a lawyer who either the timing of a jury instruction or the way it's delivered or the language itself, they wanted to propose an alternate? What would be good advice on how do they approach a judge about that? You're like, when do you think, wow, that was a good argument? No, but that was a good argument. When do you sort of feel like, what's your advice on that?
My advice to an attorney that is submitting a special request is the closer that they can make that special request match up with a pattern jury instruction, the more likely it is that I am going to give the special request. But not only must it be matched up, they must have some authority for the change that they're requesting. They can't just pull it out of thin air. There needs to be some authority and some argument made that this is why the pattern instruction's not adequate for this particular case. And that's the best thing they can do. If you just go out and pull a case from California and some pattern instruction that doesn't have any basis in Tennessee law and doesn't look like anything that we're used to here, in other words, it doesn't correspond with our pattern instruction, it's not very likely that I'm going to give that instruction.
It's also helpful if they present a case with that instruction. There's some law involved that says why we should charge it.
And then let's talk about the jury themselves. If you receive a question from a jury on the jury instruction, do you answer it? Or under what circumstances do you answer it?
Well, our case law says that we should answer the jury questions if we can. There are some things that we can't answer. I'll be trying a DUI and on a guilt phase of a DUI, and the first person has 2 prior offenses. And when they're deciding whether or not he's guilty of DUI, they'll ask the question, has he ever done this before? And we really can't answer that question. Then there are questions like, what does this word mean? And sometimes we can give them a definition. Sometimes my answer is, it's in its ordinary common use in the English language. But we can't really say, I'm not allowed to answer that question. We have to try to, usually the instructions should be so clear and plain that they don't really need to ask a question. A lot of times they ask questions just because they're having trouble fitting the law to the facts of the case. And they just want some hint. They want us to give them some hint about how they should decide it, and we're not allowed to do that.
How do you handle questions from the jury on instructions, Judge Ward?
Well, first of all, we require that the instruction be submitted to the judge in writing, and we make that written document an exhibit to the case. And before the jury comes back in the room, I discuss that with both sides, and we try to come to some mutual agreement as to how I should answer the question. Sometimes I cannot answer the question, and that's the answer they get.
Sometimes I refer them to the instructions that were previously given to them, and sometimes I provide additional information, but I'm very careful about that because I need to make sure that the parties are in agreement or that I'm absolutely sure that that is what the state of the law is in Tennessee. So I have to be very careful, and at the same time, we're not allowed to comment on the evidence in any way in our answers. So it's a variable situation depending on what the nature of the question is.
I agree with Judge Ward and answer jury questions the same way. Believe it or not, the most asked jury question that I get is, can we have a copy of the transcript? Or, what did so-and-so say?
We would like to see the police reports.
Yes, and that type of thing. And, of course, you've got to deal with that. But there's a recent case that came out about the necessity for having both parties present when you review, like Judge Ward said. And I'm a little concerned about a case that I just handled, that pending motion for new trial. A lot of times the jury will go out and deliberate a long time, and it's hard to run down the attorneys sometimes when you've got a question. And in this particular case, I can't remember the exact question, but it was a no-brainer answer. Like, I'm sorry, I can't answer that, or I'll refer you to such and such part of the instructions. And I went ahead and did that without the attorneys being involved in that situation. Since that case came up, I'm a little bit concerned about that issue, and it's going to be real interesting.
I will say this, we've talked about the preliminary jury instructions and the timing. All of my preliminary jury instructions tell the jury that you're going to listen to the evidence one time and one time only. You will not be provided with a transcript, and you cannot come back out here and ask us what a witness said. But nevertheless, I agree with the other judges. They still come out and say, what did that witness say?
I will usually tell them, if I play that back for you, I will have to play back the entire trial. And at that point, they change their mind about wanting to hear the testimony.
So what changes, we're on the 22nd edition of the pattern jury instructions in Tennessee, so what changes should we expect in this edition?
We had about 200 changes made. The legislature passed a bunch of new laws, new crimes. They just repealed elder adult abuse crimes and enacted new crimes. So we have to put dates on the old instructions that they can only be used for crimes happening before January 1st of 2000. And then we had to draft some new instructions, because when this new book comes out in October, people will be starting to try the cases that happened this spring. And so every time there's a change in the law, the elements of crimes, or every time there's case law that redefines a word in the charge, then we have to make those changes. So they can be anywhere from death penalties down to shoplifting cases, all kinds of different words and crimes. Slight things. As an example, just a few hours ago we discussed the fact that in elder abuse, we have caretakers who take care of elderly people, and they will take the money from the elderly people. They'll say, give me $10,000, and a 95-year-old elderly person will give them a check. Well, in the past, the police would arrest someone when the family complained that the caretakers were getting money from them without their permission. And the elderly person would say, well, I want to. I'm 95, but I want to give this money. And so the legislature made a little exception that if the person consents to it, it's not against the law. And that was just a little tweak, one of probably 200 changes in the law this year. And so we had to change the jury charge to say, with a little parenthesis, unless they have their consent. Because if we try a case 5 years from now, whether it happened before January 1st of 2020 or afterwards, the judge will not know unless we document it all. The judge won't know whether or not consent should be put in the instructions or not. The judge won't even think about it. So we have to make these changes so they're very apparent to the judges, so it will jump out to them so they'll know to make the right changes.
You asked about the procedure earlier, and Judge Kraft answered that question, and he's kind of a modest fellow. In all honesty, the committee meets 3 times a year to discuss these changes. Judge Kraft spends the entire year reading everything the legislature does to change the law, and also spends the entire year reading the appellate opinions that discuss jury instructions. And he almost single-handedly does the updating of all of this material. And at the same time, all during the year, judges from all over the state are calling him to discuss the problems they're having with these jury instructions. So he serves sort of as the clearinghouse of all the judges. And so he might be kind of modest, but without Judge Kraft, the pattern jury instructions would not be near as complete and comprehensive as they are now. And they stay current because of Judge Kraft's dedication to making this happen.
So if you're a judge and you have a concern about a jury instruction, it's Chris Kraft is who you should be emailing?
You should be calling him or emailing. Sometimes they call me by mistake, or if they can't get him. But I usually put them on hold and call Judge Kraft and then get back on the phone and tell him my brilliant answer.
Well, it's the chairman's job.
Yeah, but the point is, if you have a question about a jury instruction or you have a concern, there is an outlet for you. There is a committee. The committee has chair and vice chair, so you should be communicating with them what your concerns are.
And with that particular fact situation of that judge, we might think, we need to change this instruction and put a comment. If you have this fact situation, you might want to make this change in the instruction. And a lot of this is for the judges who very seldom try a criminal case, and they need these instructions to help as a guide to them, to help them with that. If I had to try, I've been a criminal court judge for 25 years, if I had to try a divorce case or a civil jury trial, I would need all kinds of help.
So at what point would you need to go back to old jury instructions? Is a case is being retried or sent back on appeal, and how do you find old jury instructions? Because it's obviously, we talked a lot about the updating, but sometimes you need to know what was the jury instruction, pattern jury instruction in 2015.
In this coming February 2020, I'm going to try a death penalty case. They're asking for the death penalty for a man, and the murder happened in 1979. And so I have to go back and get the instructions for then. I can get help with that, plus certain changes through that. And I have this problem with other judges too. They'll have someone who's been in the penitentiary for 20 years, or they'll have a cold case. We have a lot of particularly sexual assault cases where the DNA is discovered and it happened 15 or 20 years ago, and we have to go back and get the instructions from back then, because otherwise it's an ex post facto law. The laws have changed. And so the AOC, the Administrative Office of the Courts, keeps all of our old charges and I have all of our books and all of our loose leaf charges before we had books going back to 1993 in my office.
So the lesson to be learned is never throw away a pattern jury instruction book, because as soon as you do, you'll need it for a case that's sent back for retrial after multiple years.
One of the things we do every year is we delete, or try to delete from our book, all of the crimes that have been abolished for over 10 years. But we put a footnote in there, if you have to try this, then here's the book that you need to consult to do that. Because otherwise our book would grow so big it would be 2 or 3 feet thick.
So, but if you didn't keep all of your old jury instructions books, where do you go?
We would have to just write our own instructions. We don't want to reinvent the wheel. No, we keep, and the old loose leaves, I keep mine, but they also have stacks of them that are kept at the they tell me they're kept, the Administrative Office of the Courts. Some of them I'm sure are probably digitally produced now. But we have to keep all of those old things, because new judges that come along don't even remember the old laws. From 1982 to 1989, we started judge sentencing for the first time. Before 1982, jurors were doing sentencing. The instructions were completely different. And so a lot of people aren't caught for a while. A lot of people are in the penitentiary for a long time, and the state just doesn't extradite them until later. And so we have to always keep everything so that we don't have to reinvent the wheel again.
And is that a common reason for appeal, because the wrong instruction was given, like the wrong dated instruction?
Yes, when we have those negotiations you talk about, The attorneys usually bring up something about the instructions, so if their guy's convicted, they have something they can appeal.
So let's talk about the future. So how do you think the pattern jury instructions are going to evolve over the next 10 years?
Well, I can speak to California. They have them all digital now, and so attorneys, for a fee, because it's a private publisher, they can go on in civil and criminal, and they can pull their instructions down from the web and assemble them all and bring them to court, and they file them ahead of time for the judge to look at. Both sides, or 3 or 4, however many parties there are, they all have their own set of instructions, but they're all digitized, and there are templates they fill out. And at some point, I think that will happen in the state of Tennessee. But right now, we have physical, although there are digital instructions on the disc that the judge has. Our publisher, Thomson Reuters, publishes the book, and it's physical. And so our attorneys, our prosecutors and defense lawyers don't have a digital copy of that. All the changes we made today will be on the web in 3 weeks, but as soon as our book is published next July, that will be wiped, because obviously Thomson Reuters can't sell books if it's free on the web. But we've made this arrangement with them. But a lot of states, and some of the states, California bought the software for that, and they're using that as a fundraiser in California. And I think someday in the state of Tennessee that will probably happen.
How do you think the jury pattern instructions are going to evolve, Judge Ward?
I agree with what Judge Kraft said. I think we'll continue to do what we've been doing for the time being, and as long as Thomson Reuters
Is willing to provide the judiciary with free copies of the book, we'll continue to provide the manpower to update it.
What about sort of the idea of more plain language and more multimedia and visual sort of representations of things? Do you kind of see less words at some point, or probably not?
Well, we always have to balance between the words that the appellate courts tell us to use and an attempt to make them more understandable by the jury. And we've tried that, and that's why we have certain instructions that have alternatives in more modern language. And I think we'll continue to try to make it more understandable by the jury. But at the same time, we have to be careful to continue to have the actual words that the courts have told us are approved.
There's a constant tension between the exact legislative language and common sense language. I had a fellow on the stand, and a lawyer who was using big words said, did they detain you and interrogate you? And he said, no, sir, they just kept me there asking me a bunch of questions. He didn't really understand those long words. And so we have to make sure that the jury understands them, but if they're so plain and vague that the jury could misconstrue them, then we can't do that. And so there's an art to trying to frame the language that way. And the legislature, we used to have a lot of lawyers in the legislature, we don't anymore. And so they have lawyers that draft things for them, and they draft them to be legally precise, and we have to explain them to normal people, citizens of Tennessee.
And Judge Gay, how do you think the pattern jury instructions are going to evolve?
I agree with Judge Kraft and Judge Ward. We're going to have to continue on this committee to do things on the ground level 3 times a year, to review the new case law, to review new legislation. We're going to have to consider each instruction and what we can do to make it as simple as possible, yet comply with the law. And we just got to continue to balance out those issues. Also, I agree, digital instructions are going to come into play, but basically I think we'll continue to do the same thing, same review.
Well, thank you all 3 of you for being the guests on Tennessee Court Talk today.
Our pleasure.
Thank you.